Wayne is how important it is to your credibility to be yourself and to be real. And Wayne is always Wayne Heller. He carries it off very well. And you might not always agree with him. You might find him offensive, but he's going to be himself. And that is how he obtains so much credibility in the courtroom. Enough so that he's had not guilty findings in a murder case where not less than 7 witnesses identified his client as the shooter. And drug cases where his client possessed over 24,000 grams of cocaine. And I'm sure that Wayne's ability to obtain results like that comes from his just natural gift of being real. So without further ado, Wayne Heller.
Thanks, Dossie. There's been one small change of plans today, folks. I had originally planned to do this talk alongside the king of comedy himself, Chuck Rosenthal, our former district attorney, but Chuck called me recently and had to cancel. He told me he just didn't have time to speak to us today. But that's bullshit. Let me tell you what really happened. The guy had a nervous breakdown. He was out at his ranch. He stepped in this huge pile of cow shit. He looked down and he thought he was melting. Folks, if I offend anybody today, well, get in line. You won't be the first, you won't be the last. It was George Bernard Shaw who said the secret to success is to offend as many people as possible. But you're friends, so I hope I don't offend anyone here. What I do want to do is start by sucking up to the PD's office. I love you guys. When I heard there was going to be a public defender's office in Houston, I got really excited. And when I saw the team that Alex put together, it just exceeded my expectations. When I see young lawyers like Craig winning every trial he has, and appellate lawyers, trial lawyers like Eric, who asked me to do this today, thank you, Eric, for the opportunity. And I see not just the young ones like Damon, but the old guys like me, and like Randy Martin and Bob Wyckoff. I got to tell you, it warms what's left in my little black heart. Because I got to say, this profession is very subject to burnout. I mean, we get our collective asses ridden by the judges every trial we have. Our clients often disrespect us. Their families talk down to us, especially if you're a public defender. My personal favorite is being told by some 30 minutes out of law school, dolled up debutante against crime. That's not how her court works. So yeah, we get burned out doing this, folks, and I look at these young idealistic lawyers kicking the state's ass, and it's a beautiful thing. Please keep up that great work you're doing. And I'll give you an example of how the PD's office has been a boon to even the private sector practice. If y'all been trying cases in Houston for a long time, you will have heard this, and it just drives me crazy. You're in the middle of trial, and there's always some esoteric evidentiary issue that arises. And these judges will look at their prosecutor and say, call appellate, meaning the appellate division of the DA's office. Now, if that's not the fox guarding the hen house, let me go with a sports metaphor. Can you imagine a ball game where there's a hotly disputed call and the referee turns to the home team manager and says, what do I do? That's what we get in Harris County, folks. But the playing field has now started to level. And it is with great pleasure in that situation. I look at the judge and say, you want to know what the law is? Call the PD's office. Thank you for that little luxury, folks. It just makes me feel like I'm working with a net. Okay, before we get started in earnest here, I want to tell you what I'm going to do. And there's an old speaker's creed. Tell them what you're going to tell them, and then tell them what you told them. And that's going to be one of the themes I want y'all to take out here today. If there's anything that the Republicans have taught us in the past 30 years, it's that if you repeat the same bullshit over and over again, there's a large segment of the American population that's going to believe it. So I suggest what you do is you get a trial theme. Short, doesn't have to be sweet, but people are weaned nowadays in a 30-minute television show. They expect these cases to be simple. They're simple-minded folks. That's what they get in church, that's what they get on TV, that's what they get in every walk of their life. That's how to communicate with these people. This is why politicians have entire complex issues boiled down to one sentence, a slogan. Ask any ad guy who does psychology of consumers, and they'll tell you, you don't have a long time to get through to these people. And I'll give you another example of how this is done. Go to Hollywood with your screenplay and try and sell it. You're lucky if you get 10 seconds with a producer, a money man, which is why all Hollywood films can be boiled down to a one-sentence treatment. That's what they call it, a treatment. It's a thriller movie. It's a vampire movie. It's a romantic comedy. We need to boil our trial themes down to one sentence. I want to give you a couple examples that you can use in almost any case. But clearly, the better themes are going to be fact-based on your case. So let me start with that example. And I'm going to give credit to that shiny bald head hiding behind the computer over there, Dave Cunningham. He and I were set to try a horrible sexual assault of a child back in the late 80s against a lady named Belinda Hill, who 5 years into the case ended up dismissing her. And I was so proud of the theme we came up with that we never got to use. So please let me pass this on, and somebody out here use this thing. Our client was an interstate truck driver, and he ended up marrying a woman who had a 9 or 10-year-old daughter. This young woman, the daughter, had never ever known her own father. He ran off on her before she was even born. And all of a sudden, our client shows up. And what happens? He steals half her mama's love, just like that. For 9 or 10 years of her life, it was her and her mom. Now all of a sudden, she's got to split that love with her dad. Now the next dynamic that was going on in this family is the mama, to compensate, spoiled that girl rotten. So what did her new stepfather have to do? He had to become the disciplinarian. He was the guy who said, no, you can't skip school. No, you can't go out with a 16-year-old crackhead. And of course, he wasn't there all the time either. He was an absentee stepfather because he was an interstate truck driver. So we wanted to tell the jury, this case involves a school board. And it's all about the 3 R's. Remember those? I'm not talking about reading, writing, and arithmetic. I'm talking about resentment, rebellion, and revenge. We had that blown up in posters. We were going to hit it in Fort Dyer. We were going to hit it in an opening, cross, direct, closing, hammer that same thing, resentment, rebellion, and revenge. She had always resented father figures. Her own father walked out on her. She was rebellious like all teenagers, and this case was her revenge. My favorite fact, Dave came up with her library card at school through a subpoena. God knows why this was in the school library, but she had checked out a book called How to Sue Your Parents for Malpractice. Remember that one, Dave? Anyway, somebody used the 3 R's, please. I don't want it to go unused forever. How about a theme that's more general? They don't have to be that fact specific. It's great if you can. But even if your theme is as simple as Johnny's innocent, 2 words. That's what you want to communicate. How about, remember the old Wendy's commercial, where's the beef? How about, where's the proof? And here's a trick that you can use in every single case you handle. Don't talk about the evidence they do have. Of course, you should address the evidence they do have. But folks, we ought to be talking about the evidence they don't have. Make a list, especially in a dope case. Hit the case law, and you will come up with dozens and dozens of affirmative links. Write everyone out you can find, and tell that jury these links are conspicuous by their absence. The cop doesn't have the fingerprints on the baggie of dope, does he? There was no dope in your client's hair, right? That's what they did to Mayor Marion Barry of Washington, D.C. When he got busted, the FBI came in, clipped a little hair off his arm, tested for cocaine. Why don't these officers do that? Officer, did you test my client's urine for cocaine? Did you test his blood for cocaine? Did he run away from you? Did he have a gun? Does he have any priors for drugs? List every single possible bit of evidence they could have, and then you take it to the next level, folks. It's not just that they don't have this evidence, and the jury will get very suspicious of that. These folks are weaned on shows like CSI right now. They want DNA on every case. They want fingerprints on every case. As you all know, I've been doing this 33 years. So far, I've had 1 case with fingerprints and 1 with DNA, but the juries don't know that. Take it to the next level. I like to tell these juries, everybody in this courtroom has a job. The judge's job, he's the referee. The prosecutor's job, that's to put my client in prison. My job is to stand up for his rights. Your job, folks, is to find out whether or not the government really can prove their case beyond a reasonable doubt. But what's the cop's job? The cop's job is to gather evidence and to bring it to you to make your job easy. What did the cop do in this case? He sat down that night and he thought, do I want this jury to know his fingerprints aren't on that bag of dope? Do I want the jury to know there's no cocaine in his blood? Do I want the jury to know there's no marijuana in his hair follicles? No. I want him to face a situation where it's my word against this common. And here's your transition, folks. Don't let the government condemn its own citizens with such a weak attempt. They didn't do their job. They didn't gather evidence. You can use this in every single case you handle. No matter what evidence they have, there's always 10 more things that they didn't do. And that right there is a great thing that you should be pushing every single time. All right, now what I want to do here is sort of a broad overview of a trial with 2 or 3 tips, tactics, and lots of jokes along the way. So let's start with voir dire. Now, one of the things I like to do in voir dire is to wake these people up. It's a speaker's technique called the hook. Just like today, I walked out, first thing I did is I want a punchline to loosen people up. Well, remember, these jurors have just sat through an hour of a judge politic, another hour of the DA boring the crap out of them. So what do you want to do? You want to contrast your personality and your style to theirs. And that's not difficult to do. How about this? It's kind of a dumb joke, but this is the kind of joke you tell the jury. I like to get up there and look at them all. First thing I say is, y'all just discovered the toughest way in the world to make $6 by listening to a bunch of lawyers carry on. Now, it's not the funniest joke in the world, but it serves a purpose. Self-deprecation. If you can't laugh at yourself, you've got no right to laugh at anyone else. And when I talk about comedy in the courtroom, please, folks, be careful with this. You're playing with firecrackers. Don't joke about a rape victim. Don't joke about a kid or anyone who is hurt in any way. These jokes are for dope cases, DWI cases, theft cases, cases where there's no real victim. But if you're going to joke, start by joking about yourself. Tell some lawyer jokes. It's really a way to humanize yourself. They're expecting you to be an arrogant son of a bitch. And of course I am. But I gotta fool these people. Say something about lawyers and how boring they are. Okay, it really goes a long way with juries. I think you'll be amazed. Here's another fun trick in voir dire, and this is very aggressive, folks. You're gonna piss off the DA when you do this. And I suggest to you, if you're not pissing off the DA, you're not doing your job right, okay? If the DA likes you, what that means is you're rolling over, and you don't want to do that. It's bad for your reputation. You don't want these people to like you. They're the evil guy who's trying to put your client in prison. This is not a popularity contest, folks. It's no coincidence that the most hated lawyers in town also happen to be the best lawyers in town. That's called a pattern, cause and effect. So try this technique. This really pisses them off. It's another one you can start with right out of the chute. We just heard this young prosecutor get up here and tell you that he wants fair jurors. He just wants people who will be fair. I say that's a bunch of bull. You can believe that if you want, but let me tell you what's really going on. He wants jurors who will convict my client. And I'm going to be a little more honest about that. I want jurors who will understand this young man is innocent. I want fair jurors. I want people who have a mind open enough to understand the government's railroading this guy. So when he tells you he wants fair jurors, you can consider his credibility, because that's about as honest as he's going to get in this trial. Now, it's going to piss him off. And I don't know about y'all, but I'm prepared to live with it. It's kind of fun when you get used to it. It's scary at first. It really is. All right, here's a lovely little tip in voir dire that I stole from Tim Evans, out of Fort Worth. And I believe that he was channeling Warren Burnett at the time, the legendary West Texas lawyer. You know, you always hear the demographic warnings. Watch out for rich-looking white guys on the jury, anyone with a Rolex and a fancy suit. White males went 95% for George Bush. They're almost all pro-prosecution. Put black guys on the jury, put Hispanics on the jury. Their families have more trouble with the law, they don't trust the police. Here's one, strike Asian males when you're going to a jury on punishment. Also Lutherans, because they're very harsh on punishment. Well, Tim Evans said, throw those all out. Don't even think about that. There's only one that you should always, always follow. That's this. Never put anyone on a jury who has lips like a chicken's asshole. My point is this, you go through your life scowling and being mean and ugly, and it shows on your face. Now, I didn't used to believe that. I'm an old hippie, and I used to thought you can't judge a book by its cover. Bullshit. The last words George Orwell ever wrote were in his journal. He said, by the time people turn about 30 years old, everybody pretty much has the face that they deserve. You think about it. You go through your life worrying about your clients, your hairs fall out, your beard turns gray, okay? You go through your life scowling and being mean and nasty. That's where you get this look, okay? So watch out for those chicken lips, folks. Okay, here's another good one, and one of my heroes, rest his soul, is Doug Tinker out of Corpus Christi. I vividly remember all his CLEs because he did what I'm doing now, folks. He just told jokes the whole time. And he gave a really good tip at a DNA seminar I went to, I think back in '98. He said that, ask the jury panel, does anyone here actually know what the letters DNA stand for? And if anyone raises their hand, you strike that son of a bitch. Because they know too much. You know, off topic, I'm going to tell a joke here. It's a Doug Tinker joke. He told it at the same seminar. And if you haven't been offended yet, well, then just sit back and here it comes. Tinker told a horrible story. He was a lawyer, by the way, who represented the person who killed Selena. He also got a not guilty verdict in one of the Branch Davidian cases. Little bitty guy, didn't like to wear shoes, looked like Santa Claus. He had a sweet little voice like this, and he was hilarious. I had co-defendants with him once in the Valley, and he just cracked me up. But he told a very serious and very scary story about a doctor that he had represented down in Corpus Christi. It was a sexual assault case, and it was horrible facts. This doctor was charged with sexually assaulting 7 of his patients, all of whom had been put out under anesthesia in his office during day surgery. And the evidence, Tinker said, was just overwhelming. They had linked up the doctor's DNA to sperm samples taken from the vaginal tracts of all 7 of his patients. So, of course, the jury convicted this doctor. And Tinker said, we were really trying it on punishment. We thought it was a probation case. But the jury sent the guy to prison. Tinker said it was a real shame, too, because that guy was the best vet in Corpus. That's horrible. Okay, don't tell that one to Jerry. It's okay. Please. I just had to throw that in an honor of Doug Tinker. All right, let's move on to opening argument. Sure. You know, I'm not loud enough for you. All the studies say that 80% of people, jurors that is, have their minds made up by the end of the opening argument. That's a scary thought. They haven't heard any witnesses at all, but they have their minds made up in opening argument. So if you're waiving opening, I say that's malpractice. Understand that they go directly from your daughter to the state's case if you waive your opening. That state's case can last who knows how long, but you don't want them to go 1 or 2 or 3 days of trial without hearing your side of the story. So you need to pull the carpet out from the state's case early on and tell these folks where you're headed. And that's the purpose of an opening argument. You get up there and you tell your story. That's how people have been taught to communicate for thousands of years. Isn't the Bible just a collection of stories? Not only that, but with television nowadays, that's how people learn. So that's our job, folks. We are the modern day storytellers. You should get up there and tell your story. And don't say anything you can't prove, but say something and tell the jury where you are going with your case. This is very, very important. And when you do this, may I suggest that you cut out all the lawyer crutch language. When I was a young lawyer, I would get up there and I'd say, ladies and gentlemen of the jury, I submit to you the state can't prove their case beyond a reasonable doubt. Take the red pencil of that, folks. Cross it all out. Here's your opening. Johnny's innocent! Don't dilute the strong stuff with the weak stuff that wins nothing and means nothing. I read an interview once with Rodney Dangerfield. He said when he writes a joke, he will literally, physically write it down on a piece of paper. Then he looks at that joke word by word by word and takes out every single word that does not make that joke funny. And he's left with a bare bones one-liner. And that's how our openings need to be. Take out the words that don't help. Go with your strong stuff. Don't dilute your message. But whatever you do, tell your story. Tell them where you're going. Really, really important. And you're going to get a lot of objections. The DAs love to object during opening. That's not evidence. Courts is not evidence. We haven't heard from witnesses yet. But you're allowed to tell them what the evidence is going to be. So when a DA objects, I don't like to do it, but invoke the magic words. The evidence will show this is what's going to happen. Now, after one or two times, if the DA is still objecting, try this technique. Just turn to the DA and say, the evidence is going to show, and then you go on and tell your story. It's like, Mother, may I? Is there really a magic incantation where we have to invoke these special words? No. 2 or 3 times of staring them down and going, Mother, may I? They'll shut up. And I want to jump ahead to the section I have on objections, because the same technique can be used there. It drives me crazy. I'm in final argument, and I got a roll going. And I'm really into what I'm saying, and the DA starts objecting. That's not in the record. No, whatever the objection is, it's bullshit. It doesn't matter at this point. I love this technique, and it has never failed to work. I often write out post-it notes, 6 or 8 of them, and I line them up across the base of the podium. The first objection I get from the DA, I look down at my first post-it note. The judge is going to overrule their objection usually and give you a little leeway in argument. But don't go right back into your argument. Here's your transition. The first post-it note says, what the DA is trying to keep you all from hearing, but the judge says you're allowed to consider is this. Then you go back into your argument. They object again. What they're trying to hide from you, but the judge says you need to know this. Try those. Put it right in their face. When they object, turn it into, that's the government intensely trying to hide the truth from you. And if you make them mad, good. That's the whole idea. Because these people are wrapped too tight. You see them, they pee in their pants when you ask for probation. You know, it's like it says on the side of firecrackers, folks. This is how I try cases. Light fuse, stand away. It's not hard to rattle their cage. In the article I brought up today, there's a whole section called Rattling Their Cage. Put them off their game. They're not expecting it. And there's tons of tricks in this article that you can do to rattle their cage. It's something that, it's a very effective technique because we don't win these cases, they lose them. You know, I asked Rusty Harden how he got a not guilty verdict on the Calvin Murphy case. A couple of Calvin's kids said he'd been molested. I said, what are you, a magician? What voodoo did you tell these people? He said, Wayne, I didn't win that case. He said, the red-headed judge in this courthouse and lost the case. That's the point. All we have to do is be in the game. We've got the lead to start with a presumption of innocence. We don't start at the 50-yard line. We start at their goal line. Stay in the game and let the DA lose it. And the way to do this is to rattle their cage and light their fuse. It's good fun, too.